I'm criminal defense attorney Joseph Abrams. Today's video is the last in a three-part series in which I explain the federal criminal process in easy to understand terms. Previously, in part 1, I discussed the investigation and pre-trial phases. In part 2, I discussed the trial phase. This week, in the final installment, I discussed the sentencing phase. So let's talk about the sentencing phase of the federal criminal process. After a defendant pleads guilty or is convicted at trial, the case proceeds to sentencing. It's important to keep in mind that between the conviction date and the sentencing date, many important events take place in preparation for sentencing. One of the most important of these events is that the Federal Probation Office conducts a pre-sentence investigation of the case, which includes a formal sit-down interview with the defendant. The probation officer will also speak with any victims of the offense and allow them to submit victim impact statements. The probation office will then issue to the court and the parties a pre-sentence report, which includes a description of the offense, a summary of the defendant's criminal history, the calculation of the federal sentencing guidelines, and a sentence recommendation. After the pre-sentence report is issued, the parties will file their response to the report and set forth any objections they have to the report. The parties will also file their own sentencing positions wherein they set forth what they believe is the appropriate sentence and reasons for it. After all papers have been filed and responded to, the sentencing hearing is held. At the sentencing hearing, both parties are allowed to present oral arguments in support of their sentencing positions. The defendant also has the opportunity to address the court during what is known as allocution. However, the defendant is not required to make a statement to the court. After all arguments and statements are in the record, the judge will announce the sentence in the case. Depending on the type of case, the sentence can either be a term of imprisonment followed by a term of supervised release or a non-custodial term of probation. Other parts of the sentence can include community confinement, house arrest, restitution, fines, and special assessments. It is important to note that any term of supervised release or probation will include a number of other restrictive conditions that the defendant must abide by. These can include community service, drug testing, drug treatment, employment restrictions, and formal reporting requirements. In closing, I want to emphasize that sentencing in federal court is a formal and complex process that can result in the imposition of significant and harsh sentences. A defendant can best achieve a positive outcome in their case by having an experienced federal criminal defense attorney with expert knowledge of the federal sentencing guidelines and federal sentencing advocacy. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening to this three-part series on the federal criminal process. I hope it was helpful, and we'll see you next time.